Wheel, the matter of Navigator Equities Ltd.
Good morning, Mr Craig.
Good morning, my lady. The representation I imagine you're aware of from the skeletons, but I appear with Mr Wheel for the claimants, and Mr Pellegrini's counsel with Mr Aku and Ms Young appear for the respondent. In terms of housekeeping, I hope we're all up to date. We have, I trust, a core bundle, 2 supplemental bundles, an additional materials bundle, and 2 authorities bundles. There may be one that we noticed relatively late on that reference is made to one of the many interlocutory rulings in this case, which didn't make it into the authorities bundles or even the additional material bundles, but we'll hand that over at a convenient moment if that's all right.
Thank you.
I hope you may also have received an indication as to our intended timetable, which is that I will be on my feet until about 3:30 today. Melandra Friend will be on his feet until about 3:15 tomorrow, and I'll have the last hour to wrap up. As I am sure you are aware, there are essentially 2 issues that we are addressing today and tomorrow. The first is whether or not there was a breach of the undertakings, and the second is whether or not the committal application was an abuse. You will also have seen possibly reference to a claim for damages which was not successful, but the permission to appeal in relation to that was not granted. So that needn't detain you. What I was proposing to do is to say a few words by way of introduction as to the context in which the undertakings were given and against which we would invite you to be interpreting them, and then just deal with the 2 issues of whether there was a breach and whether the application for committal was abusive. So if I could start then with contextual matters, and I was going to do it largely by reference to the chronology, which is in tab 6 of the core bundle.
And I should have said, Mr Craig, that you can assume that we have read widely.
I'm grateful and not surprised. Just then to remind you, picking up the chronology, the background started in the early mid-2000s with a joint venture between Mr Deripaska and his company Filatona and Mr Chernukhin and his company Navigator for the development of a large site in central Moscow. Things went tolerably well for a while and then not so well, and ultimately that led to an armed takeover by Mr Deripaska and that occurred in December 2010. It may have been apparent from what you've read that my client has been living in England, in fact now got British nationality and has been, I think, since late 2004. The takeover led to all sorts of discussions and negotiations which ultimately proved fruitless, so arbitration proceedings started in November 2015, and essentially the issue was whether or not the conduct on behalf of the Deripaska parties was oppressive, prejudicial to the interests of my client in the joint venture vehicle, which was a Cypriot company called Navio. So the 2 corporate vehicles, Navigator, which was Mr Chernukhin's company, and Filatona, Mr Deripaska's company, owned shares in the joint venture vehicle Navio. And Navio being a Cypriot company, the question was that there's a sort of Cypriot equivalent roughly to section 994 of the English Companies Act, protecting shareholders against oppression. And the question was essentially whether the armed takeover and a number of other matters constituted prejudice. Mr Deripaska and Filatona challenged the jurisdiction of the arbitration tribunal on the basis that he said my client was not, in fact, the joint venture partner. It was a lady called Ms Danilina, whose name was on the contract, but we ultimately satisfied the tribunal and subsequently Mr Justice Teare that she was not the true party, and that the true party to the joint venture was my client, Mr Chernukhin. It is, and you will have seen reference to this, and we'll come to the relevance of it in due course, but you may have seen reference to the fact that the ultimate outcome of the Arbitration Tribunal and Mr Justice Teare rejecting Mr Deripaska's case on jurisdiction led to the conclusion that Mr Deripaska had run a knowingly false case in the arbitration. He had simply lied as to who his joint venture partner was, and he had paid Ms Danilina $2 million with a possibility of a further 8 or 10, I can't remember the exact numbers, for her to give supporting evidence, which Mr Justice Teare held that both knew was false. Whether that's relevant to the application to commit and to the abuse argument or not, we'll come to later, but I'll just mention that as part of the context. So the jurisdiction challenge failed on the grounds that my client, Mr Chernukhin, was the true party, not Ms Danilina. There then was the substantive merits hearing before the Arbitration Tribunal. If we just go over in the chronology to March 2017, we had the merits hearing, which dealt with the question whether or not the armed takeover and the various other acts complained of did or didn't involve a prejudice in relation to the interests of my clients in Navio, the joint venture vehicle. And that then led to the arbitration award 7th of July 2017, resolving the substantive dispute in my client's favour.
87.5 million or thereabouts, is that right?
Yes, I can't remember the exact numbers. I mean, ultimately it gets to about 90 million with some interest, I think, here and there. Yes, it's of that order. And then the next important development you'll see in the chronology is April 2018, when US sanctions are imposed. It is part of the context, obviously, that the sanctions were imposed by reference to Mr Deripaska's perceived proximity to the Russian governmental machinery. That then prompted a concern that Mr Deripaska, facing sanctions, would be tempted to retreat his assets to Russia, where he obviously exercises considerable political influence, and that that would make enforcement of the arbitration award extremely difficult. If in that context we can just leave the chronology briefly and look at Ms Berard's first witness statement, which just gives the context for the application that was made for the worldwide freezing order. So that's in the supplemental bundle 1, tab 1. And if we look at page 2 at the bottom, paragraph 9, she says, 6th of April 2018, and it's been widely publicised in the international press, Mr Deripaska was made the subject of sanctions by the United States authorities. Those sanctions have had a significant and direct impact on Mr Deripaska's assets, and it appears that Mr Deripaska is now taking steps to liquidate certain of his most significant assets in the short term. Furthermore, the claimants are concerned that the wider effect of the sanctions is to encourage Mr Deripaska to repatriate his assets to Russia, where, for the reasons set out below, I believe he retains substantial influence and or otherwise take unjustifiable steps to restructure his assets in a way which will make it more difficult for third parties to enforce against him. So that was essentially the context in which the application for the worldwide freezing order was made. The point is picked up again, just very briefly, page 18, paragraph 66, 19th of April 2018, my firm wrote to BCLP, then representing Mr Deripaska, referring to the sanctions and the consequent deterioration of Mr Deripaska's business interests, and setting out our concern that as a result of these developments there would be no assets against which the sums awarded pursuant to the second and third awards could be enforceable. In that letter, my firm requested that Mr Deripaska either provide voluntary security in respect of both the claimant's costs in the Section 67 proceedings and the arbitral awards, or provide a comprehensive and detailed list of his non-Russian assets worldwide. And obviously the interest was in non-Russian assets for the reasons that Ms Berard gave. And then if we just flip on quickly to page 25, paragraph 75.
Sorry, the reasons given include those at paragraphs 90 through to 93. Sorry, 90. Sorry, you said the reasons for interest in non-Russian assets.
Oh, I see. Yes,
includes the reasons given in paragraphs 90.
Exactly. Well, that was yes, exactly. That's the sort of the punchline of this little journey through the statement. I'm grateful. You're clearly well ahead already. I was just going to mention on the way to that paragraph 75, which identifies sort of headline findings of the tribunal about the dishonest case run by Mr Deripaska and the fabrication of evidence. And 76 dealing with the circumstances of the armed takeover. That not being mentioned in order to raise prejudice, but the significance of it is explained in the context of the application for the worldwide freezing order in paragraph 78. I believe that it is an indication of the extent to which Mr Deripaska is beyond the reach of law enforcement agencies in Russia and or actively protected by them, that he or those acting on his behalf were able to execute an armed takeover of a substantial property site in central Moscow, involving at least 30 men without any repercussions, whether criminal or civil, in Russia thereafter. Furthermore, I believe that it may be inferred that Mr Deripaska would be in a position to carry out unlawful acts in relation to other property assets in Russia. And then it goes on in paragraph 79 to discuss Mr Deripaska's influence within Russia and his ability to influence through state organs the Russian justice system, and references made to other findings to that effect. And then over the page at 29 we get to the passage my lady just referred to, but that's preceded by the repetition in para 89 of the concern that there's a real risk that Mr Deripaska will take steps to repatriate assets to Russia, where he apparently enjoys substantial protection of the Russian authorities. And that then also explains, well, we've got this bundle. If we just look at the next tab, the worldwide freezing order was granted, and you'll see at page 41, paragraph 4, the operative part of the order, restraining removal from England and Wales, any assets up to the value of 87.5, or in any way disposing of, dealing with, or diminishing the value of any of his assets, whether they are in or outside England and Wales, up to the same value. And the significance of the claimant's concern with regard to the valuelessness of anything in Russia is simply illustrated by the order which we invited the court to make, and which the court did make in paragraph 7c on page 42, in determining the value of the defendant's assets, pending further information pursuant to blah, blah, blah. No account shall be taken of any such assets based in Russia, regardless of whether such assets are held through shares in companies outside Russia, save for the defence interest in shares in companies quoted in the London or Hong Kong Stock Exchange. So if we can just, with that in mind, bundle the supplemental bundle away briefly, go back to finish the chronology. We then, we were at May 2018. June 2018, we have the return date of the 19th of June, return date of the worldwide freezing order for Mr Justice Knowles. And then, as you will have seen, there's discussion of the undertakings in front of the judge and an agreement in principle that they will be acceptable. And then the undertakings are themselves signed. And I'm sure you will be aware that there are 3 undertakings which all operate together. They're in tabs 12, 13 and 14. I imagine you've probably looked at them already, but there are the 3. There's the B Finance Limited undertaking, B Finance being the registered holder of shares in EN Plus, which is sort of the flagship asset. So there's the B Finance undertaking at tab 13, which is the operative part is paragraph 5. It's an undertaking that the company will arrange for the share certificates to be given to Reynolds Porter Chamberlain, RPC, that the company, B Finance, wouldn't dispose of the shares or otherwise deal with them, and that it would irrevocably instruct RPC to hold the share certificates, and if the judgment against the Deripaska parties in the arbitration isn't paid, sufficient shares would be sold in order to realise sufficient to pay the amount of the award.
But the definition of shares is in paragraph 3.
Yeah, absolutely. I wasn't going to make submissions yet. I just want to rattle through the context. The second element in the structure is the RPC undertaking, which is an undertaking to hang on to the share certificates and not to deal with the shares. And again, an undertaking pursuant to instructions received from B Finance to facilitate the sale of sufficient shares if the Deripaska parties don't meet their judgment liability. And the third element in the package is the undertaking from Mr Deripaska personally, which had 2 elements. As you may recall, that's tab 12, not to take steps or procure the taking of steps, whether directly or indirectly, which have the effect of preventing, impeding or obstructing the fulfilment of the B Finance undertaking, and a positive obligation to take all steps as are necessary to ensure that the underlying assets, being the 45.5 million unencumbered shares in the EN Plus, legally owned by B Finance, remain available for direct enforcement. So those were the package of 3 undertakings. And then just going back to the chronology at tab 6, page 92 of the bundle, you'll see that later in the year, November 2018, EN Plus's board approves the redomiciliation of EN Plus from Jersey to Russia. There is then the hearing before Mr Justice Teare, which is essentially a rerun, a retrial of everything that was decided in the arbitration. It was jurisdiction and all over again, and we had again live evidence and so on. December 20th of December is a key date. 20th of December 2018, there is the general meeting of EN Plus, at which the necessary majority of shareholders did approve the redomiciliation. Under Jersey law, it required what's called a special resolution, but in that jurisdiction, that means a 2/3 majority. And it's common ground that B Finance held a 54% shareholding in EN Plus. The one date that isn't in there that you may just want to insert to remind yourself is that on the 29th of January 2019, the sanctions on EN Plus were lifted. So that is significantly before the redomiciliation actually took effect. The redomiciliation, as we'll see, didn't in fact get completed until July that year, some 6 months later. Going back to the chronology, February, Mr Justice Teare's judgment is handed down. If you want to note, I'm not going to go to it now, but it's in the authorities bundle at tab 24. And then in April, EN Plus's board approves the redomiciliation. And then 29th of May 2019, RPC write to Clifford Chance, who were then representing my clients, notifying them for the first time about the redomiciliation and its impact on the undertakings. And I imagine you may have looked at that letter already. It's in tab 4 of the supplemental bundle 1. And the detail of it, again, I will address by way of submission in due course. But just to look briefly at what it says, Supplemental Bundle 1, Tab 4, page 62. And it refers at paragraph 2 to the lifting of the sanctions on the 27th of... Is it 27th? I had a note of 29th. But anyway, it's late January 2019. The lifting of the sanctions, and then the press release referred to at paragraph 3 under the terms of their removal of AFX list of specially designated nationals and blocked persons. EN Plus have reduced Mr Deripaska's direct and indirect shareholding in these companies and severed his control. This action ensures that the majority of directors of EN Plus will be independent directors, including US and European persons who have no business, professional or family ties to Deripaska or any other specially designated nationals, and that independent US persons vote a significant block of the shares of EN+. So the lifting of the sanction is clearly linked there to the renunciation by Mr Deripaska of control, not to anything to do with redomiciling EN+ from Jersey to Russia. The sanctions had not been imposed because EN+ was incorporated in Jersey, and the sanctions were not lifted because EN+ was being redomiciled to Russia. The sanctions were lifted because Mr Deripaska was renouncing his control and independent directors were being appointed. We can go on. The companies have also agreed to unprecedented transparency, and then over the page, paragraph 7 is the other one that we just, 7 and 8, are the ones that we need just to mention to understand the sequence of events. 7, we are instructed that once the continuance of EN+ takes place, its shares will be held in dematerialised form, i.e. shareholder certificates will not be issued to shareholders. The existing shares and share certificates in respect to a Jersey domiciled EN+ will automatically be cancelled, including the share certificates held by RPC, pursuant to the undertakings previously given by Mr Deripaska, B Finance, and Mr Boswell of RPC in respect of 45.5 million certificated shares in EN+ owned by B Finance, the undertakings. All shareholders in Jersey domiciled EN+ will, at the point the continuance is completed, automatically be granted new shares in Russia domiciled EN+ on a one-to-one basis, and then the GDRs will continue to be traded. 8, the current undertakings refer to certificated shares in EN+ and are based upon the Jersey share certificates in EN+, being held by RPC. In light of the continuance of EN+, the undertakings will, with the permission of the court, need to be withdrawn. And then that was followed in June by a letter at the next tab. You can just look very briefly at that, 26th of June 2019. If we just look at paragraph 11 on page 66 of the bundle, we can confirm the following in response to the specific queries at paragraph 4 of your letter. For the 21st of June, the Russian Central Bank registered the issuance of shares in EN+. On the 24th of June, we're instructed that whilst it's not possible to give a date, the anticipated date for which EN+ will be registered in Russia as a Russian legal entity remains, as set out in our letter, around 4th of July. I'm instructed, however, the date of registration outside the control of EN+. And then the last 5 lines of the paragraph are important. It is upon the registration of the Russian legal entity that any shareholder would, if minded to sell all or part of its EN+ shareholding, be required to sell its shares and or GDRs relating to those shares in the new Russian entity, and would no longer be able to sell its shares and or GDRs relating to those shares in the Jersey entity. paragraph 12, absent a change in position by your clients, it appears that our client will be left with no choice but to issue an application to seek the court's permission to withdraw the undertakings in light of the continuance of EN+. Now, you'll recall that the judge said that this was provocative and that the position then changed. But in our submission, it is entirely true that the undertaking in relation to the share certificates, if nothing else, was valueless once redomiciliation was effected. And as I understand the Deripaska party's position, Mr Deripaska's position, he has never resolved from that point. The undertaking in relation to the share certificates is valueless because they relate to shares that don't exist anymore. There are new shares in a Russian entity. The question, a slightly abstract question, whether the Russian entity is the same legal entity as the Jersey entity, in our submission is a red herring, because we're not talking about concepts of continuity of legal entity. We are talking about whether or not an undertaking has been broken. And the undertaking of three interlocking undertakings related to certificated shares in the Jersey entity. So just going back then to the chronology, we see in June 2019, 4th of June 2019, just to note, Mr Wisniewski is replaced as a Director of B Finance. 26th of June 2019, the claimants apply for an order requiring Mr Deripaska to make a payment into court because they're concerned that the value of the undertakings has simply evaporated, and so they need replacement security. Although not mentioned in the chronology, Mr Deripaska made a cross-application to be released from the undertakings. He then withdrew that, as you may have seen, in front of Mr Justice Teare, who was hearing it on the 3rd of July. Proceedings were also taken in the Royal Court of Jersey in order to try getting a transfer of the shares in EN Plus Jersey before they ceased to exist. We then get 3rd of July, as I say, the application, the hearing before Mr Justice Teare, and I won't go to it now, but the judgment in that is in the authorities bundle at tab 27. 9th of July, the redomiciliation takes effect. Then 25th of July, my clients issued an application for wide-ranging injunctive relief against Mr Deripaska, requiring payment by specified date, and in default of that, sale of assets in order to meet the judgment that had been made against him. 29th of July, Mr Justice Teare does grant injunctive relief. 15th of August, he dismisses the Deripaska application to vary the order of the 29th of July, save some limited elements. In September, there's been obviously quite a lot of activity in the long vacation. 5th of September, Mr Justice Bryan dismissed Mr Deripaska's application to set aside part of the security ordered by Mr Justice Teare. Then finally, a significant date, 30th September 2019, Mr Deripaska pays the sums ordered by Mr Justice Teare on the 3rd of July, and as a result, a few days later, the undertakings are discharged by consent. The committal application is then issued about 6 weeks later, and you will no doubt have looked at that. Just for your note, it's in this core bundle at tab 10. 6th of February 2020, the Court of Appeal dismisses Mr Deripaska's appeal against the judgment of Mr Justice Teare in relation to the substance of the trial. There's mention, I can just bring you up to date, actually we can add one other date to this. There's mention in our skeleton of an outstanding application by Mr Deripaska to take that Court of Appeal judgment to the Supreme Court. As at the date the skeleton was written, that was still pending, but the Supreme Court has refused permission to appeal, and that I think was December last year. Just popping back to February 2020, that's the Court of Appeal judgment, and that now is the last word. And then the committal application comes on before Mr Justice Andrew Baker, with the cross application by Mr Deripaska to have it struck out as an abuse. And after hearing argument first on the question of abuse, Mr Justice Andrew Baker gave an extempore judgment dismissing the application for committal as an abuse. But he then went on subsequently to hear argument on the following day or days of that hearing as to whether or not there had been a breach in any event. And he subsequently gave a reserved judgment on that in July, dismissing the claim for damages and finding that there hadn't been a breach either. So we are now in front of you in relation to that. My purpose in taking through that chronology was essentially twofold. One is to point out that the undertakings that were given were all an interlinked package. There was no point in RPC giving an undertaking to hang on to share certificates and to sell them if there hadn't been an undertaking by B Finance to give RPC those shares and an undertaking by B Finance not to deal with the shares itself. And none of those would have been any value if Mr Deripaska had not given his undertaking not to take steps to hinder or prevent the performance by B Finance of its undertaking. So the three undertakings are inextricably linked, and they only work in combination with each other. And my second purpose in taking you through that brief chronology is simply to point out that the whole impetus for applying for the worldwide freezing order and the granting of the offer to give undertakings in substitution for the worldwide freezing order was all prompted by the claimant's concern that the result of the sanctions would be that Mr Deripaska would withdraw his assets to Russia, where he has sufficient, by one means or another, sufficient influence to render enforcement of the judgment impossible, or at least extremely difficult. So the whole point of the undertaking regime was to ensure the availability of assets. We were never worried as to whether or not Mr Deripaska had enough money somewhere to pay us. We weren't worried that he was too poor. We were worried about where the assets were and how readily accessible they were to enforcement. And we do submit that as part of the contextual material that we would invite you to take into account in construing the undertakings, it is relevant that that was not only our concern, but that was an issue which was recognised by the Deripaska parties and their advisors in the way that the undertakings were offered. And my learned friend, Mr Fenwick, Queen's Counsel, who was then representing Mr Deripaska, sought to persuade the court, or sought to persuade me through the court, so to speak, to accept the undertakings. So far as that point is concerned, we've seen, so far as our clients' concerns are expressed in the Berard 1 witness statement, which we've already seen. The difficulty of enforcement against Mr Deripaska in Russia is not something that I think I need particularly to labour. You will have seen reference, and I won't go to it, but you'll have seen reference in our skeleton to a judgment of Mrs Justice Cockerell, who granted security for costs in my client's favour on the basis that there was a risk of non-enforcement in Russia. And that's in the authorities bundle at tab 22.
Are you going to give us the reference for Mr Fenwick's oral submission?
Yeah,
Coming to
I
that?
will. I'm just about to come to
Thank
that.
you.
I just wanted to put this the
Yes.
difficulty in Russia point first. So the Danilina and Chernukhin judgment on security for costs is authorities bundle, tab 22, paragraphs 66 and 67. It's worth also referring to a letter from the firm then representing Mr Deripaska, Burton, Copeland, Leighton, Paisner, in May 2018, in the immediate run-up to the acceptance of the undertaking. So this was the first sort of offer letter, so to speak, and that's in the additional materials bundle at tab 2. And the point that I want to draw to your attention is on the last page, page 21 of the bundle, paragraph 4, where having outlined the proposed package, BCLPs say the effect of these arrangements will be that Mr Deripaska will have made arrangements for assets with a value well in excess of £125 million, of which he is the ultimate beneficial owner, but not the direct owner, to be made available in London, to be held pursuant to paragraph 4 of the order, and offer them as security for the purposes of paragraph 9E2 of the order. It's the in London. They knew that was the bait. And the same point is then picked up in the witness statement of Mr Ray, who was then the solicitor on the record. In the next tab, and if I could invite your attention to, we haven't included the whole thing, but if we just pick it up at the bottom of page 23, paragraph 11, under the heading Undertakings, he says the form of the undertakings which have been offered can be seen in the 3 drafts. And then over the page.
Sorry, where's his?
I'm so sorry. It's bottom of page 20. We're still in the. Still in the additional materials bundle.
Yes, my fault. Thank you.
Tab 3, page 23. Paragraph 11 at the bottom of the page refers to the package of undertakings that were then in draft and being offered. And if we look at the top of page 24, again, he's making the same point as was made in the letter of a week or two earlier. The third line from the top of the page. Whilst those undertakings speak for themselves, what is essentially being proposed is that a block of then 33.5 million shares in EN Plus, which on a very conservative estimate are worth not less than 160 million, should be held by RPC pending the outcome of this litigation. It's the same point. It's where the assets are and who's got them and how easily enforcement can be achieved. It's held by RPC that matters, and that is the first selling point that Mr Ray identifies as being the function of the undertaking. And that same theme was picked up, just to answer Justice Carr's question, the same theme is then picked up by leading counsel. If we put that bundle away and look briefly in supplemental bundle 1 at tab 3.
Just before you leave that, the reference to paragraph 9E2 of the order is to
Worldwide freezing order.
a paragraph of the worldwide freezing order that says it will cease to have effect if the defendant makes provision for security in a method agreed with the claimant's legal representative.
Yes.
And that's formal security, as I would read that order.
Yes.
And so the formal security is the lodging of the share certificates.
Yes. Yes. The explanation from leading counsel in the first supplemental bundle at tab 3, if we can look at page 56 of the bundle, you get 4 pages to a page, but if we look in the top right hand corner of page 56, we have page 18 of the transcript. The last 2 lines of page 18, what Mr Deripaska has sought to do, this is Mr Fenwick, Queen's Counsel, speaking for Mr Deripaska, what Mr Deripaska has sought to do is not simply to identify assets which would satisfy the court's criteria of 125 million, so as to cover the amount which Mr Deripaska may be ordered to pay, and fairly ordered to pay, but actually to provide some means by which the court and Mr Chernukhin can be satisfied that if Mr Chernukhin wins, he will get his money. And the point, sorry, that goes across to the left-hand page for 19, and that is then expanded at the bottom right-hand corner, page 20 of the transcript, just between F and G, after an inaudible. Thirdly, the suggestion that the sanctions make it easy or likely that Mr Deripaska will retreat to Russia with his assets is unsustainable in circumstances where the bulk of his assets are those held in relation to the JV shares in EN+. So what was being said is that the value of the undertakings package was that it was not going to be retreated to Russia. And if we finally just look in the same divider at page 60, page 60, page 33 of the transcript, so the top left-hand page, last paragraph on that page, between F and G, that in itself, in my submission, effectively gives the court comfort that those shares will be, in effect, immediately available for enforcement. So it's actually security by another route than a mere freeze, which identifies shares and lets him do anything he likes with his assets outside England and Wales, so long as he doesn't diminish them below the value, the £87.5 million. So it's much better than a normal freeze would be. There is no question of him taking assets out of England and Wales. And that is entirely consistent with how Mr Deripaska's solicitor described matters after the event. If we look in the same bundle at tab 7, Mr McGregor's second witness statement. We look at page 106. Page 106, para 43 of McGregor 2. He quotes the operative part of the B finance undertaking, and then he says the shares are defined in paragraph 3 of the B finance undertaking as 45.5 million shares of EN+ held in certificated form. It was envisaged that the sale of these shares would be effected via the transfer of their share certificates. The relevant share certificates were therefore deposited with RPC, with Mr Boswell giving an undertaking to take appropriate steps to facilitate the sale of the shares if the conditions in the B finance undertaking were met. So again, it's entirely clear that the interlinked operation of these undertakings was offered and was clearly understood by the other side on the basis that what was being given to my client was security in the form of shares represented by share certificates, which were being held in London by English solicitors. Can I then turn to the first main topic, which is whether or not there has been a breach of the undertakings. So far as the context, the legal context of proving a breach is concerned, we recognise that court orders must be construed strictly, and we entirely accept that. The first, I want to take them actually in the reverse order to that in which they appear for reasons of clarity. So what I would like to do is to address you first on what the judge below referred to as Undertaking B by Mr Deripaska. And if I could just remind you of that, so in the core bundle at tab 12.
Mr Gray, sorry to interrupt. At some stage, are you going to help us with how the judge came to deal with breach after dismissing for abuse? I mean, we see very clearly that you say breach must be relevant to an assessment of abuse. It's clear from the judgment the judge took a different path. Now, how did that come about?
Well, there was argument. I didn't actually appear below, but I do understand that there was argument about it, and I think it's paragraphs 7 to 10 of the skeleton argument that was put on behalf of Mr Chernukhin before Mr Justice Andrew Baker, which is in Authorities Bundle 2 at tab 21. And we did seek, yes, it's pages 329, 330 of the bundle. We did seek to persuade the judge that it was wrong to determine the question of abuse.
Sorry,
I'm lost.
I'm so sorry.
Yes.
So that's Supplemental Bundle 2. Sorry, I was too hasty.
So we're looking for the skeleton.
The skeleton in front of Mr Justice Andrew Baker is tab 21, which should be the first tab in bundle, Supplemental Bundle 2. And what was said, if we look at page 329 of the bundle, you'll see there's a section, paragraphs 7 through to 10, where we sought to, or those representing Mr Chernukhin, sought to persuade the judge that it was wrong to hear the argument on abuse before deciding the question whether or not there was a breach at all. Now, the only departure I would offer from the way it was put then is that you'll see the heading there says strikeout application, case management. We submit that's actually underplaying the point, because our submission to you is that it is positively wrong in principle for a decision to be taken whether or not a committal application is an abuse, for that decision to be taken without deciding whether or not there's been a breach.
Or I just throw it out there, speaking for myself, with deciding, and it's a phrase you use, whether there's a strongly arguable case or some other formulation. I mean, it seems to me...
I just wonder whether I might interrupt. I'm so sorry. I was, of course, appearing below.
Yes.
There is more to this than the skeleton, and I don't know whether it's helpful to you now to tell you how it developed at the hearing. But the submission that Mill and Friends just referred you to was resiled from by Mr Mill, who didn't oppose the judge's approach after he'd initially proposed.
Whatever, thank you very much. But your position is, it may be you need to explain why you think a finding of breach is necessary before a decision on abuse, because that strikes me, speaking entirely for myself, as overstating it. There has to be a high level, not a mini trial, a high level assessment of the position on breach in order to inform an overall assessment as to whether or not the whole thing's an abuse.
Yeah.
Is that fair?
No, yes, I think that is fair. I was going to address that argument when I'm addressing the court on the question of the judge's decision on abuse, rather than I wanted to deal first with the anterior question, whether there's a breach, and then having explained that, I mean, the very, very short answer is that in our submission, the best sort of guide to this area of the law is to be found in the judgment in Sector Guard.
Yes.
Sector Guard tells us that there are, in a sense, sort of two key purposes for bringing committal applications. There is the coercive element, and there is the punitive element, bringing to the attention of the court serious rather than technical breaches of a court order or an undertaking. That's how it's put. Now, our submission, very simply, is that if the correct test for deciding whether or not there has been a contempt is to ascertain, because obviously this is not a case of a court using committal in order to coerce compliance, because compliance was no longer possible. So the only question is essentially punitive. If the question to be decided as to whether or not there has been a contempt of court by Mr Deripaska is whether there was a serious rather than a technical breach of the undertaking, that, in our submission, is a necessary element. Whether it's high level or granular may be another point, but it is a necessary element in deciding whether the application is an abuse. I don't want to anticipate too much of my submission, but the essential point on abuse is that if the application for committal pursues one of the two legitimate purposes, which is either coercion or bringing to the court's attention for consideration of punishment a serious non-technical breach. If you tick one or other of those boxes, that has got to be at least a material, it may not be determinative, but it has got to be a material factor in deciding whether or not the application is an abuse. And the judge just didn't do that. So when we get to the argument on abuse, we will simply say that he proceeded not in terms of case management wrongly, but he proceeded as a matter of principle wrongly, because he failed to take into account a relevant consideration. Right, so where I was going to go is on the question whether or not there was a breach of what the judge calls undertaking B, which is in fact the one labelled for B in the Deripaska undertaking, which is, if we can get that up, so we're in the core bundle at tab 12. Tab 12, very bottom, page 163. Undertaking B is, I shall take all steps as are necessary to ensure that the underlying assets, being the 45.5 million unencumbered shares legally owned by B Finance in EN Plus Group PLC, remain available for direct enforcement. So obviously the overarching question is whether the judge came to the wrong conclusion as to whether or not there had been a breach of that undertaking. And we apprehend that answering that question turns on, I think, if we can break it down into four subsidiary issues. One is to consider what the underlying assets means. The second is to consider what direct enforcement means. The third is to consider whether, in the events which happened, the underlying assets did remain available for direct enforcement. And the fourth question is, if not, could Mr Deripaska have taken any steps to ensure that those underlying assets did remain available for direct enforcement? So far as the first of those sub-issues is concerned, what were the underlying assets? This is where the interlinking nature of the three undertakings is relevant. Because if we look at paragraph 3 of the B Finance undertaking, which is tab 13, page 166, we see I confirm and warrant, sorry, paragraph 3, page 160, I confirm and warrant that the company, B Finance, is the legal owner of over 245 million unencumbered shares in EN Plus Group plc, a company incorporated under the laws of Jersey, EN Plus. Of these, 45.5 million are held in certificated form, the shares. So, the shares, capital S, in this suite of undertakings means shares in a Jersey incorporated company in certificated form. That is why, as Mr McGregor himself explained, RPC was given the share certificates and why it gave the undertaking it did, or he did, in fact, I think. And that is what the underlying assets are in undertaking B of Mr Deripaska's undertaking. There is no other asset relevant or mentioned. And that is why in our submission, the admissions made in the May 2019 letter were so significant. We can just look briefly at that letter. We saw one short passage in it, but if we can just go back to it for the purpose of what this undertaking clearly meant, was intended to mean, and was understood to mean, we have supplemental bundle 1, tab 4. Page 63, paragraph 8. The current undertakings refer to certificated shares in EN Plus and are based upon the Jersey share certificates in EN Plus being held by RPC. In light of the continuance of EN Plus, the undertakings will, with the permission of the court, needs to be withdrawn. And that is similarly why the June letter said what it said. We saw that, the next tab. And why Mr McGregor's second witness statement said what he said. If we can look, we saw a short passage in that, but if I could take it to some slightly lengthier passages now. Page 107, tab 7, page 107. Para 52. Para 52. I'm instructed that all shareholders in Jersey domiciled EN Plus will automatically be granted new shares in Russia domiciled EN Plus on a one-to-one basis. The new Russian EN Plus shares will be held in a dematerialized form. Share certificates will not be issued. The existing shares and share certificates in respect of Jersey domiciled EN Plus will, upon completion of the continuance, automatically be cancelled. And then it talks about the timing of the completion of the redomiciliation, and at paragraph 54 on the 4th line, it is upon the registration of the Russian legal entity that any shareholder would, if minded to sell all or part of its EN Plus shareholding, be required to sell its shares in the new Russian entity. And para 55, which we'll come back to, but I'll just mention since the page is open, when it goes to the question of Mr Deripaska's conduct. I should note for the avoidance of doubt that the decisions taken by EN Plus Board of Directors and its shareholders in respect of the continuance are outside of Mr Deripaska's control, albeit it is acknowledged that Mr Deripaska did, via B Finance, vote in favour of it in EN Plus's shareholder vote. We can just look also, while we've got that open, over the page, page 109, paragraph 61.2. The Jersey share certificates currently subject to the GDRs will no longer be valid.
I'm sorry, where was that?
Sorry, that's para 61.2.
Thank you.
Page 109.
Yes.
And then on the next page, 110, para 63, as matters stand, and consistent with my comments above relating to the continuance, upon continuance, 1. B Finance's paper share certificates held by RPC would no longer serve any purpose. And 2. B Finance would become the legal or registered owner of the new electronic shares in Russian EN+. And finally, page 112, para 74. The current undertakings will, upon completion of the continuation, no longer be workable in the manner contemplated because the sale procedures set out in these undertakings specifically relate to the certificated shares in Jersey Company EN+, and prescribe a process for the sale of those shares using the share certificates. That is all in our submission not only right, but unarguably right, and cannot sensibly be withdrawn. The judge, with respect, as we will see, and my learned friends seek to dodge the effect of the redom by submitting or deciding in the judge's case that the Russian entity is the same legal entity, and that therefore some shares in a company called EN+ exist. I'm not going to enter into a debate about whether or not the Russian entity can, in some sense, or for the purpose of some legal abstract principle, be regarded as the same legal entity. That's not the debate. The question is whether this undertaking was violated. And in our submission, in circumstances where the acknowledged effect of the redomiciliation was that the undertakings given in relation to the certificated shares became valueless, unworkable, no longer workable. In our submission, it is the case that there was a breach. And the point, if finally, again, that was Mr McGregor's second witness statement. If we can finally look at his first affidavit very briefly, which is in tab 16 of the same bundle.
Before we do that, just going back again, I think the same point that you've already referred to in 74 is also made at 54 at the end. As such, from that date, it will no longer be possible to sell the EN+ shares and provided in the current form of undertakings because the mechanism relates to the certificated shares. This has precipitated the timing of the application, seeking the court's permission to lift and withdraw them.
Exactly. Yes, your lecture is quite right, and I'm sorry I didn't.
No, it's just exactly the same point that you were making, but it's also in 54. Sorry, Mr. Craig, you were taking us to...
Not at all. So Mr. McGregor then made an affidavit in response to the application to commit, which is why we've gone from McGregor 2 to McGregor 1, from a witness statement to an affidavit. We just look very briefly, so we're in tab 16 of the same bundle. If we look briefly at paragraph 124, we see the same point again. 28th of June 2019, RPC served the Deripaska party's application to lift the undertakings on the basis that, 1, the continuance rendered them unworkable. That's para 124, first two lines. And while we've got this to hand, if we just look at page 273, paragraph 198. He says at the beginning of 198 that the question whether or not there's been a contempt will be a matter for legal submissions, but in this regard I refer without limitation to the following points. 198.3. The nature of the undertakings shares did not change until the continuation completed in July 2019. Now, the only fair reading of that affidavit is that the nature of the undertakings shares did change on completion of the redomiciliation. So, first subsidiary point, we submit the only sensible interpretation of the expression underlying assets in undertaking B is the certificated shares. Second subsidiary point, what does direct enforcement mean? Mr Deripaska's undertaking requires him to make sure that the underlying assets remain available for direct enforcement. And this feeds back in. I can take it quite shortly because I've given you the contextual points and I've foreshadowed the argument. Why is RPC holding share certificates? Because enforcement directly was intended by both sides to be effected by a transfer of the Jersey entity's shares represented by those share certificates. That's what direct enforcement meant. We were relying on an English solicitor's undertaking in relation to share certificates held in London. That's what direct enforcement meant. The third subsidiary issue then is, did the underlying assets remain available for direct enforcement? To which you will, I'm sure, appreciate that we say the answer is no, for all the reasons that we've really already covered. Because the shares, capital S as defined, meaning the underlying assets, no longer existed. There were no certificated shares in a company incorporated in Jersey to which the share certificates held by RPC related. As a result, those share certificates were valueless. As a result, the RPC undertaking was valueless. As a result, enforcement against the underlying assets was literally impossible because the underlying assets as defined no longer existed. And, for what it's worth, enforcement against the substitute assets, namely uncertificated shares in a Russian legal entity, was precisely the onerous and potentially impossible task that my clients intended to avoid and the Deripaska parties intended to assure us would be avoided by the undertakings. Because enforcement against Russian company shares, uncertificated, was precisely the kind of process that would necessarily involve proceedings being taken in a jurisdiction where Mr Deripaska exercised a kind of political influence that we've seen. So the fourth subsidiary question, what steps could Mr Deripaska have taken? Well, in compliance with his undertaking, he could perfectly easily have paused the 54% shareholding in EN Plus to be voted against the redomiciliation. So say the resolution needed a 2/3 majority. That majority could not have been achieved if the B Finance 54% block was voted against the resolution.
And it's said against you, Mr Crowe, in that regard that, in fact, the value of the Jersey shares was going to plummet, and accordingly, in fact,
Yeah.
a favour was being done.
Yeah, indeed it is. I was going to deal at a slightly later moment with the argument based on the sort of the concept of impossibility, but essentially our short answer to that is that if it is literally impossible to comply with a court order, that may well not involve a contempt. But simply because it is onerous, burdensome, inconvenient to comply is no answer. So the hard-edged answer is that the fact that it may have been very unwelcome to comply with the undertaking is no answer to the allegation of contempt. And secondly, perhaps in a more sort of practical tone, if Mr Deripaska genuinely took the view that it was commercially undesirable for the redomiciliation not to go ahead, what he should have done is what he says in his own witness statement. His own affidavit. What he says he should have done, which is to go back to court first and get the court to approve either a waiver, discharge, variation, or release from the undertaking to some extent, which would have given my clients the opportunity of obtaining some kind of substitute security. I won't go to it now, but it's Mr Deripaska's fifth affidavit.
It's tab 17, and he says he and Mr McGregor apologise.
I'm grateful.
And so they should have come back to court.
Yeah. So that's the sort of the two answers we give. It wasn't impossible to comply, and if he thought it was really important not to comply, so to speak, he should have got the courts to waive. Now,
well, the undertaking doesn't say take all reasonable steps or commercially sensible steps. It says all steps.
Yes, exactly so. Now, very briefly then, the judges, how did the judge get to a different conclusion? Essentially, we say that the judge's main error is that he simply failed to give value to the fact, or fails to recognise or understand the fact that the undertakings, the three undertakings, represented an interlinked package, and the point of the package was to provide available assets in this jurisdiction. And if one just sees the section of his judgment, I'm not going to read it in extenso, but the section of his judgment that deals with this is paragraphs 113 through to 190. And the fact that he is, with the greatest respect, looking at the undertakings with completely the wrong perspective is most apparent from para 113 at the bottom of page 127 of the bundle. The claimants would be wrong in any event in the necessary premise that the redomiciliation had the effect to prevent, etc., B Finance from selling enough of the shares to make good a relevant Deripaska default if there was one. That is because, and this will bring me to undertaking B and the only argument of any possible substance, prior to the intervention of the Jersey court, B Finance was as free to sell its shares after as before the redomiciliation. Well, no doubt it was. That is of precious little comfort to my client, who may want to force it to sell. The judge then does touch on the real point in paragraph 114. But he simply says this: the possible concern, in the middle of that paragraph, the possible concern of substance could be that whereas an English court order directing B Finance to sell some or all of the shares might be expected to be readily enforceable in Jersey, not so in the Russian SAR if the claimants would need to go there to procure a court-directed sale. But none of B Finance's undertakings said anything about that. In short, B Finance did not promise the court, either in terms or by any of the language of the promises it did give to the court, that EN Plus would remain a Jersey entity.
So you say that's wrong?
Yes. I mean, in substance, it's wrong. There isn't in
Not in terms a promise, but it's a promise in respect of the Jersey shares.
Exactly. And there was acknowledgement that that had become unworkable. So with the greatest respect, the flaw in the judgment here is that it simply doesn't. And he makes the same point at the bottom of at the bottom of that page in para 117, the last few lines. The insuperable difficulty for the claimant's case is that Undertaking B does not say that the shares had to remain shares registered in Jersey. Well, it doesn't use those words. But the only sensible interpretation of the Undertaking is that it does relate to certificated shares in the Jersey entity, which is why the package of undertakings was structured as it was. Incidentally, there is one very small point as to whether or not the judge was right in refusing to construe the undertakings by reference to the fact that a worldwide freezing order was being surrendered. I just wanted to mention that point. It's paragraph 49 of the judgment. But with the greatest respect, we do not understand how it could be irrelevant to judge, to construe the undertakings in the context of the fact that they were being offered as a substitute for the worldwide freezing order, because each one of the
fact that Mr Deripaska said he had good grounds to challenge doesn't alter the fact that WFO existed and you were giving it up.
Exactly. And every one of the three undertakings starts with the words, I am writing in connection with a worldwide freezing order. It's the first line of the Deripaska undertaking. It's the first line of the B Finance undertaking. And it's the first line of the RPC undertaking. They are all writing in connection with a worldwide freezing order. The judge's second main error. So our first point essentially is that the judge, to put it colloquially, he just didn't get the significance of the structure of the undertakings as a package and their intended effect. And the outcome he reaches just doesn't give value to the definition of the shares and what direct enforcement necessarily meant in the context of that package. There are other incidental points that we would suggest illustrate the errors that the judge made. In paragraph 119, he dwells on the supposed ambiguity in the undertaking. I mention that. In a sense, I don't have anything new to say in answer other than that. The ambiguity he identifies in our submission is a false one. He says entirely truly that the expression available for direct enforcement isn't a term of art or a phrase with one clear and obvious meaning. Well, it may not be a term of art, but in context, it did have a clear and obvious meaning. But the ambiguity then identifies, with greatest respect, in our submission just isn't there. He says the ambiguity is whether the enforcement in question is enforcement of Mr Deripaska's monetary obligations, should he default, or enforcement of the B Finance undertaking, should it default. And in substance, the argument comes down to this. The claimant says the former, Mr Deripaska says the latter. In our submission, that just isn't a valid ambiguity. The only, clearly, with respect, the undertakings are talking about enforcement of the liability to pay the shares, and the share certificates and the shares were to remain available for direct enforcement. The only relevant question was what direct enforcement meant, and in the context of these undertakings, our submission is that the answer is very clear, and the judge simply, having observed that available for direct enforcement is not a term of art, simply doesn't give any value to the expression direct enforcement.
And you'd say that arises also because he doesn't look at the undertakings as a package and see it in that way. Exactly so. And a third point, I don't want to spend too long on this, but a third point is that the judge decided, as you may recall, that the May 2019 letter was provocative but misleading.
Well, he says that repeatedly.
He does.
And you're going to come back to common ground, I know, aren't you?
Yeah.
The fundamental misapprehension section of your skeleton.
Exactly.
All right.
Exactly.
Okay.
I was going to come back to that. But, I mean, the short answer is that we do not understand the Deripaska parties ever to have resiled from the admission in the May 2019 letter that the value of the RPC undertaking literally disappeared. We do not understand them to pretend that the undertakings should be construed in ignorance of each other. And we do not understand them to have resolved from Mr McGregor's evidence that the purpose of the package of undertakings was to effect enforcement through a transfer of the certificated shares. So, my learned friend will no doubt take you if I'm wrong on any of that, and those points have been resiled from. A learned friend will no doubt in his submissions take you to that. But we don't understand where the judge got his idea that either we accepted that the shares in the Russian entity were the same as the capital S shares in the Jersey entity. That was never part of our case. And we don't understand where the judge got the idea that the Deripaska parties had resolved from all parts of the May 2019 letter. They did try running the argument that the undertakings of B Finance applied or extended to the shares in the Russian entity. But that, in our submission, doesn't get them home as to whether or not there's been a breach of the undertaking, because the undertaking, as a package, as I say, relates to the enforcement through the sale of the transfer of the certificated shares.
Can I ask a question? Thank you. I mean, at some stage, it would help me, speaking entirely for myself, to understand a little bit more as to how it could be that the judge said so many times it was common ground. Very shortly after the May 2019 letter, and certainly by the time of the hearing before Mr Justice Teare and thereafter, that the May letter was wrong and the shares as defined in the B Finance undertaking were destroyed. Sorry, were not destroyed. And we picked that up first, I think, at para 88, and it's all over the judgment.
It is.
And yes, so at some stage, when it's convenient.
Yeah. Well, I think at least part of the answer, when this may be the substantial part of the answer from my client's perspective, is that one of the statements of Ms Berard does say that her understanding, although she says it's a matter for legal submission, she does say her understanding is that the undertakings of B Finance would extend to the shares in
And you'll come to that. That's one paragraph in Berard 4. Berard 4 was not the affidavit relied upon for the contempt accusation, which was Berard 8, which is replete with destruction and valueless. Exactly.
And as far as you're concerned, that's the only peg?
As far as I am aware right now, yes. But as I say, because I wasn't at the hearing below,
no, that's why I flagged it up. I would like to know exactly what happened.
For sure. The final point I just briefly want to deal with on this is I was just going to quickly revisit the question of impossibility. Was the judge right? He says in paragraph 121 of his judgment, he says he's glad to have reached the conclusion he did, because he thinks that my learned friend, Mr Pillow-Cooey's counsel, was right also, that on the claimant's construction of the undertaking, Mr Deripaska may have been put in an impossible situation. And he gives the explanation for what he means by that. And my learned friend seeks to pick that point up and run with it in his skeleton argument. saying that if our interpretation were correct, then Mr Deripaska would, he says, have been in an impossible position. And the short answer to that is that, as I say, we don't accept that it was impossible to comply. We accept it may have been very unwelcome, but if he had recognised, as he did later, that it was very unwelcome, what he should have done is to do what he recognised later, which is to have returned to the court. And my lady Justice Carr has already got that point. It's paragraph 7 to 9 of Mr Deripaska's fifth affidavit. And the same point, just incidentally, is made not only by Mr Deripaska but also in Mr McGregor's first affidavit at paragraph 197. Just touch very briefly, we haven't had any case law yet, just to touch very briefly on some case law on that.
Sorry, on impossibility?
Yeah, on impossibility.
When you took us to the either the May or the June letter, your point was that actually the US sanctions had been lifted without and before the redomiciliation.
Yeah, they were.
So does that affect this point?
Yes, it does. It does. I mean, the factual finding the judge made, and I can't go behind this, was that although the sanctions were lifted because Mr Deripaska reduced his interest and independent directors were appointed, the evidence that was put in front of Mr Justice Andrew Baker, which he accepted, was that part of the financing to arrange that was with one of the Russian banks, and one of the conditions that the bank imposed was that there should be redomiciliation. And so there are some references in the judgment to the interlinking between the lifting of the sanctions and the redomiciliation.
So it's not as simple as
it's not. The two are not wholly divorced from each other. But the lifting of the sanction, I mean, simply as a matter of what the whatever it's called, OFAC, the US regulator, did not require redomiciliation in order to lift the sanctions, as demonstrated by the fact that the sanctions were lifted 6 months before redomiciliation. So, in order to achieve a lifting of the sanctions, on its face, redomiciliation did not have to occur. But as I say, Mr Deripaska's evidence was, and we can't go behind it, was that part of the financing did require redomiciliation. Just on impossibility then, we would submit that if it can be shown that a court order or an undertaking is literally impossible to perform, and if the impossibility hasn't been brought about by the alleged contemnant himself, then that might well be an answer. But the one authority that my learned friend himself relies on is perfectly clear in saying that there is a very principled distinction between inconvenience and difficulty of performance on the one hand, and impossibility on the other. And it's the case of Perkia Foods, which is in, I don't know if, do you have any one authorities bundle?
Two.
You do have two, okay, fine, good.
1 to 23 and 24 to 26.
Okay, good, so it's the last one in bundle 1.
But you say this isn't impossible, and even if it were impossible, the impossibility would have been brought about by Mr Deripaska because that was the terms of the finance.
Yeah. And his solution was not to go ahead regardless, but to come back to court. Very briefly, so Perkia Foods, it was a dispute between a food supplier and a manufacturing company about the production of food snacks. And it was unusually, a mandatory injunction was granted requiring the manufacturer to produce food snacks conforming to a particular contractual specification. In the event some of the products that supplied were so poor of quality as to be unsaleable, there was a contempt application, and the defence was that the orders, as specified in the contract, simply couldn't be fulfilled because the recipe didn't work were the only machine that the defendants actually had, which was the only one in the country. On the point of the difference between impossibility and difficulty or inconvenience, could I just draw your attention on page 471 to paragraph 11. I won't pause to read it. Paragraph 11 quotes a decision of Mr Justice Mayles in Westminster City Council in Adbins, whether the principle, so page 471, para 11, whether this principle of impossibility should be extended to a case where compliance with the order is not impossible, but is difficult or inconvenient. And if I could draw your attention to that paragraph 11, well, through to 15, but 15 in particular.
Do you want us to read 11 to 15?
I would, perhaps, if I could just invite your attention to paragraph 15 now. I think the 12, 13, 14 are surplus to requirements, but 15 I'd be grateful.
We'll just read that then.
Thank you.
Yes.
I'm very grateful. That is all I wanted to say in relation to the breach of undertaking B. If I could deal briefly with the breach of undertaking A, we can put the authority away and go back to the undertakings in core bundle, tab 12, page 163. Mr Deripaska's undertaking A, I shall not take any step or procure the taking of any steps, whether directly or indirectly, in my capacity as ultimate beneficial owner or in any other capacity, which has the effect of preventing, impeding or obstructing the fulfilment of the undertakings set out in the B finance letter, as they may fall due for performance. So again, the question whether there was a breach of that undertaking involves in our submission, conveniently, I think, just two subsidiary questions. The first is, did anything happen that had the effect of preventing, impeding or obstructing the fulfilment by B Finance of its undertaking? And secondly, if so, did Mr Deripaska procure the taking of those steps, whether directly or indirectly? So far as the first question is concerned, did something happen which had the effect of preventing, impeding or obstructing the fulfilment by B Finance? The relevant paragraph in the B Finance undertaking is in the next tab 13, page 167. And it's paragraph 5B. The company will not dispose of the shares or otherwise deal with them pending the final outcome of proceedings currently ongoing in the High Court. Obviously, keeping in mind what the shares means, the question is going to be whether what happened involved a dealing or a disposal of the shares. The judge said there was no breach here, and in our submission, the error he makes is that he leapt from a finding that EN Plus continued as the same legal entity to a conclusion that there had been no dealing or disposal, dealing with or disposal of the shares as defined in the undertaking. And one sees that, what we submit is a non sequitur, in para 51 of the judgment, and then picked up again in paras 108 and 109. So in 51, it's in the introductory section before he gets on to the question of breach, but we go back, so tab 8, page 109. Para 51, the effect of the redomiciliation was and is that EN Plus has continued in existence throughout. EN Plus today now incorporated in the Russian Special Administrative Region following the redom should be recognised and treated by this court as the same legal person that existed as a company incorporated in Jersey when the undertakings were given. EM Plus did not die and leave its estate to a Russian heir. It moved home from Jersey to the Russian SAR. For that reason, the 45.5 million unencumbered shares in EN Plus that existed in certificated form in June 2018 when EN Plus was a company incorporated in Jersey continued to be owned by B Finance. And there's no evidence to suggest that they had become encumbered in any way. As between B Finance and EN Plus, it seems right to say that they were the same shares before and after the company moved to the Russian SAR. That might not mean without more that the shares, as defined in the B Finance undertaking, necessarily continue to exist, because that depends on the meaning and effect of the definition. But as I've already said, it's common ground before me, that in fact they did.
So it's here, the judge seems to be, that last sentence, hesitating and going, gosh, shares as defined could be tricky, but don't worry, it's common ground.
Yes, and with respect, as I say, it is not common ground in this court. Yeah. I don't know on what basis it was thought to be common ground in the court below.
I mean, if it was such an important concession, and it's one of your fundamental misapprehensions. There's no explicit concession, nothing on the transcript that you've been made aware of anywhere that could be said to amount to a concession that, yes, we agree, the shares as defined were not cancelled, were not destroyed, but continued under the overarching umbrella of a continued company.
There is no concession of which I am aware that the shares as defined continued to exist.
Yep. And you're Leonard Jr., I think. On the contrary. Oh, yes. There's something in the transcript to the contrary. Yes.
Yeah. So, Mr Milqueen's counsel, who was appearing then, if we look at supplemental bundle 2, right, tab 26. At page 528, and I'm grateful to Milana Jr. Page 528, we get bottom left. Right, the page is in different order this time. So bottom left is page 74. Mr. Miller's speaking. Line 1. This is the point. It didn't cease to exist as a company, but it became a Russian company. In our submission, that point didn't work. Because the shares, which are referred to in the undertaking, are specifically identified as the certificated shares held by RPC in a Jersey company. So what you can't do is defend an allegation by reference to the shares, capital S, without recognising what the shares were viewed against the background of the language used in the undertakings and the factual matrix. In other words, you can't say that the shares, as so defined, continue to exist. They didn't. They were different shares, not certificated, and in a different company.
So he wasn't even agreeing as a matter of English/Russian/Jersey law that the company continued.
No, in fact he wasn't.
No.
And then at the top of the, on page 75 of the transcript, top right-hand corner, lines 5 onwards. What I'm saying is different. It's different subject matter. The nature of the shares that were contemplated by the undertaking are certificated shares in a Jersey company. The shares as shares exist thereafter, but they are not the same shares in the sense that they are uncertificated shares in a Russian company. So it's not quite the point that your Lordship is making. It's slightly more nuanced than that. I'm not saying that the shares as shares don't exist, but they are not the same shares.
And I see this is on day 4, and I know I'm irritating you by jumping around, and you're going to come to this, but these before it's so he makes the abuse ruling, and we see what he says at that time.
Yes.
But when you read the judgment, the written judgment, these considerations are all feeding into and come before the abuse ruling.
Yeah.
So you'll have to come to, as it were, if you're right on breach, not only on the question of serious misconduct, help me at least with how that feeds into the findings on abuse, which may be the key point ultimately.
I'm grateful, yes, I hope to be able to do that. Sorry, I think that was apropos para 51
Yes.
of the judgment, and then...
on paragraph 51, can I just, in the middle of that, there's two sentences. He says, first of all, beginning for that reason, the 45,500,000 unencumbered shares in EN Plus that existed in certificated form in June 2018, when EN Plus was a company incorporated in Jersey, continued to be owned by B Finance, and there's no evidence to suggest they had become encumbered in any way. I think you say that he misses the point.
Yes.
That actually you had security over the certificated shares, and you have no security over the Russian.
Exactly.
Sorry, the shares in the Russian company.
Yes.
Putting aside for the moment the question of whether it's the same company, that's irrelevant, you say.
Yeah. Exactly. Exactly.
And then he says, as between B Finance and EN Plus, it seems right to say that they were the same shares before and after the company moved to the Russian SAR. Why is he focusing on as between B Finance and EN Plus?
I don't know, and he's wrong to do so, because that just isn't a relevant question. The question is not, does BN Finance hold shares in something called EN Plus? That isn't one of the questions that he's being asked to decide. So I don't know the answer to that question.
So what is the right question?
The right question, for the purpose of deciding whether or not undertaking A has been broken, is whether or not the events which have happened have resulted in, have had the effect of preventing, impeding or obstructing the fulfilment of B Finance by B Finance of its undertaking, the relevant one being that B Finance wouldn't dispose of or otherwise deal with the shares in, the capital S shares being certificated shares in a Jersey company.
But the relevant persons as between whom the question about whether they were the same shares is the parties to the undertaking or the English court.
Exactly. Exactly. So the as between B Finance and EN Plus is an irrelevance. Absolutely. I don't know why that's addressed.
Okay. And in the final sentence, the judge does address the shares with a capital S, but then comforts himself that it's common ground.
Yes.
And he goes back to paragraph 30, that should be 39, not 38. And 39 is the May letter is wrong, and it's paragraph whatever of Miss Berard's fourth affidavit.
Yeah,
okay.
That's right. That's right. And that, in our submission, erroneous thinking feeds through into paragraph.
Actually, I had actually read back to 38.
You think it's 38?
Well, it might be, because I had another question if we're going into this.
Yeah, sure.
He says in 38, the first point he says that there was no undertaking that the shares would remain in certificated form. He says, so long as the shares were held in certificated form, having the share certificates held by RPC under the RPC undertaking might perhaps have seemed an additional comfort, but it is not suggested that they were documents of title. What does he mean by that?
Well,
I mean, the whole point about depositing share certificates in relation to certificated shares is it gives rise to a form of security, and we saw that was the basis on which they were offered pursuant to paragraph 9E2 of the Worldwide Freezing Order, as I understand it.
Yeah. The very most I can say, in kindness to the judge, is that these were not bearer shares, if that's what he means. They're not documents of title, but like any non-bearer share, they are documents that evidence title. And they evidence title in the context of undertakings where the security was intended to be in the form that if Mr Deripaska didn't pay the judgment debt, the share certificates could be transferred by RPC pursuant to its solicitor's undertaking. direct enforcement. So I think it's section 50 or article 51 of the Jersey Companies Law 1991, which states that, as does English company law, if it's not a bearer share, a share certificate is evidence of title, not itself a document of title, if that's what he means. But that just doesn't meet our point.
I think Lady Justice Carr is right. It should have been a reference back to 39, but 38 is still of interest.
Yeah, it is. It is of interest and wrong.
It's dealing with the same point that I was asking you about in the middle of 51 about the purpose of depositing share certificates.
I don't want to throw a spanner in the works and waste time, but I'm not so sure about that. I think it might be 38, because in the middle of 38, he says that B Finance did not state, let alone undertake, that the shares would remain in certificated form, and I think that is why he's seeing shares one way or another as something more fluid. And I think that leads back to 51, but perhaps we spent too much time on this already.
Fair enough. Well, it is definitely one or the other, possibly both. Maybe paragraph 38 broke into two parts in the course of drafting, one never quite knows. But just to follow through the logic of where the judge got to where he got, so he's saying what he says in paragraph 51 in the sort of the general introductory section on what is ostensibly the facts, but it then feeds into the section of his judgment dealing with whether there was a breach, which starts at para 104, and the relevant bit on undertaking A, which is what we're dealing with, is in paragraphs 108 and 109. And I'm sure you've read those, but that's just to give you the hook. That's where the point that's anticipated in paragraph 51 feeds into his answer in relation to the question of whether or not there's a breach of undertaking A.
I mean, you can see the centrality of the common ground alleged mistake from 108.
Yeah, absolutely.
Once you appreciate the shares are not extinguished, then
Then
there's
our
clearly
case
no
collapses.
breach.
Yes. Yeah, absolutely. So we simply say that there has been a misinterpretation of the effect of the undertaking. The other point I just want to deal with briefly before moving on is Malone Friend's argument. He says that even if our interpretation of what the capital S shares means is correct, he says that there was no disposal of or dealing with those shares, because he says all that happened is that B Finance voted them, and voting a share, he says, does not of itself involve a disposal of or dealing with the share. Now, as a matter of abstract legal principle, that is right. Malone Friend may take you to his cites a case called General Electric and the Plessy Company in his skeleton, and that does stand as authority for the bare proposition that merely voting a share does not in and of itself necessarily involve a disposal of or dealing with the share. But what that decision also makes clear, and in our submission is right, is that what matters when you're considering whether or not there's been a breach of an undertaking is not whether the shares were voted, but what is the practical consequence of the resolution on which the shares were voted. The practical consequence of the resolution in this case, because it was a 54% shareholding and a 2/3 majority was required, the practical consequence was that the shares, as defined, were disposed of in the relevant sense for the purposes of that undertaking, because those capital S shares ceased to exist. No certificated shares in a Jersey company existed as a result of the redom.
They were cancelled.
Yeah. Yeah. So the second subsidiary question in relation to the breach on undertaking A is whether or not Mr Deripaska procured the relevant steps, because as you'll recall, obviously the undertaking is I shall not take any step or procure the taking of any steps, whether directly or indirectly. which has the effect of preventing, impeding or obstructing the fulfilment by B Finance of its undertaking. So the question here is whether or not the judge was right to say that Mr Deripaska didn't procure the vote of these shares. And the parts of his judgment which deal with this are paragraphs, I think the important ones are paragraphs 110 and 123. Let's just stick with 110, that's what we really need. Page 127. He says, in any event, Mr Deripaska did not concede that he did anything to procure B Finance's vote in favour of the redomiciliation after having given undertaking A.
Did you deny it?
Mr Deripaska? No. Well, I'll take you through the evidence because one can only answer that by seeing the context in which his evasive evidence is given. The unchallenged evidence, evidence of Mr Makarov, Ms Kaldina and Mr Valiev all support the case that, and more specifically the proposition that, Mr Deripaska was in favour of redomiciliation and had made that known before his undertaking was given, but had no involvement in B Finance's decision-making. Now, I have to admit, my lord, I don't read Mr Makarov or Mr Kaldina's evidence as dealing with the interactions between Mr Deripaska and B Finance at all. You will reach your own views on that. Their evidence is in the supplemental bundle. It's only Mr Valiev's evidence. With respect, the judge was overstating things to suggest that Makarov or Kaldina were relevant on this issue. It is the case that Mr Valiev said he didn't take a direct instruction from Mr Deripaska, but that he knew the shares were being voted in accordance with Mr Deripaska's wishes. The judge then goes on to say this: the claimants had no contrary evidence, save to alight upon an ambiguous turn of phrase used by Mr McGregor in his witness statement for the hearing before Mr Justice Teare on the 3rd of July. Their allegation that Mr Deripaska must have taken some relevant step after the undertaking had been lodged was speculative, in my view. Can we just run through the evidence in order to put in context exactly how Mr Deripaska and Mr McGregor dealt with this point? The building blocks are very shortly these. The first is, Mr Deripaska is, on his own evidence, the ultimate beneficial owner of B Finance. We see that in a number of documents. I don't need to go to them, but just so that my learned friend doesn't think I'm blagging, we've seen it in a letter from BCLP, the one we saw 23rd of May, paragraph 4, which is in the additional materials bundle at tab 2. We see it again in Mr Ray's witness statement at paragraph 14, in the additional materials bundle tab 3. And we see it in Mr McGregor 2, paragraph 31.1, which is paragraph tab 7 of the first supplemental authority, the supplemental bundle.
Tab 7.
Tab 7.
Thank you.
So Mr Deripaska is the ultimate beneficial owner. Second point, Mr Deripaska said he would procure the B Finance would procure B Finance to provide the undertaking. And for that I do want, just because it's a striking turn of phrase, and it's in the accumulation of this material that in our submission leads to the conclusion the judge was quite wrong to suggest that our case was speculative. The additional materials bundle, if we could just look at that briefly. This is tab 2. Is the BCLP letter we looked at briefly in order to provide the context for the interpretation of the contract, of the undertakings. If we could just look on the second page of the letter, page 20 of the bundle. Paragraph numbered 1, just above halfway down the page. Mr Deripaska will procure by agreement with B Finance with a view to obtaining a discharge of the order and entirely without prejudice to our comments in para 2, which was the bit saying we were never entitled to the worldwide freezing order in the first place, that B Finance arranged to deposit with solicitors in London one original share certificate in respect of, and then it goes on. It's those opening words. Mr Deripaska will procure. So that's the second point. He's the beneficial owner. His solicitors tell us he's going to procure B Finance to do what it needs to do to give the undertaking. The third point in the accumulation of material is that in the event B Finance did provide the B Finance undertaking. So it is, with the greatest respect, a very fair inference that Mr Deripaska did procure it, as he said he would. The fourth piece of evidence is the submissions, again made, if we could go back to what Mr Fenwick, Queen's Counsel, said at the hearing in June 2018. So in the supplemental bundle at tab 3, supplemental bundle 1, tab 3, page 58. Page 58, if we could look top left, page 25 of the transcript, letter D, Mr Fenwick says, in my submission, it is clear both that Mr Deripaska is in a position to give directions which can be cascaded down the directors of the companies down the chain, would permit the undertakings to be given, which would secure what is now 45.5 million rather than 35.5 million, because there was argument about that, in such a way that they would be amenable to enforcement. He must presumably have said that on instructions. Mr Deripaska is in a position to give directions which can be cascaded down by the directors of the companies down the chain. Indirect procuring is plainly being said to be in Mr Deripaska's power. In the same bundle, at tab 15, we have Berard 8, and there is a letter quoted there which doesn't actually appear in the bundle, but if we could look at page 196.
Sorry. Supplemental
Bundle 1,
Oh, yes.
tab, so same bundle, sorry,
My
tab 15, page 196. A letter to Clifford Chance from RPC. Due to the ownership structure of the EN Plus shares held by B Finance, Mr Deripaska is able, principally because of the degree of power he holds as protector of the trust, to procure that an appropriate number of the EN Plus shares are held in a manner that satisfy the substantive requirements of freezing order. Mr Deripaska has previously proposed achieving this via a series of irrevocable instructions and undertakings to the court. So it's Mr Deripaska proposing that. And it's Mr Deripaska proposing what B Finance would do. He remains willing and able to procure that those arrangements are put in place, or such other arrangements as are acceptable to your clients, acting reasonably in respect of the EN Plus shares.
And it's mentioned there that he's protector of the trust, which presumably owns the shares in B Finance. At some stage, was that trust and the terms of it available to the court?
I don't know. I think the ownership structure is that B Finance is owned by a company I think called Fidelitas. Oh, there we go. It's the previous page. Thank you very much. Yeah, so I think we asked and we were told what the structure actually looked like on paper.
Thank you.
And it's so it's a thing called the Argat Trust.
I just wondered whether at any stage, therefore, there was the terms of the protectorship were revealed.
We will check. The recollection of my learned junior is that we asked and were refused a copy, but we can certainly check that. And I'm sorry if that's wrong.
I'm just sort of just standing back. This is a worldwide freezing order against Mr Deripaska personally.
Yes.
The whole point at a worldwide freezing order is to preserve assets for ultimate enforcement of a judgment.
Yes.
Against the defendant.
Yes.
And by definition, you enforce against assets owned by a defendant,
yes.
not assets owned by somebody else. So either these shares are owned by Mr Deripaska personally and are substituted for the worldwide freezing order pursuant to the undertakings, or if they're owned by a third party, it's critical that there's effective security over
yes.
them to enable direct enforcement of a judgment against Mr Deripaska
Yes.
against assets owned by a third party over which has decided to give security. Yes. These are either Mr Deripaska's assets or it's critical that there's enforceable security.
Yes.
Isn't that right?
Exactly. Exactly so.
Okay.
So, my ladies, my lord, that letter I think was my fifth item of evidence. Sixth point, Berard 4, which is at tab 6, makes an assertion. And
This is the peg.
this is the...
It's the peg you're taking.
Yes, exactly. Sorry, yes, exactly.
So we're still in SB1.
We're still in SB1. We're in tab 6 now.
Thank you.
And if we look at page 88,
And it's not contradicted.
exactly. So it's paragraph 66.
So it must be assumed that he knew of and directed.
Yeah, exactly. And that is a witness statement she makes on the 26th of June 2019. McGregor 2, which is in the next tab, is made 2 days later. And far from denying what Miss Berard says in para 66, Mr McGregor says what he says in para 55, page 108, which is the paragraph I've already read to you. It is acknowledged that Mr Deripaska did, via B Finance, vote in favour of it in EN Plus's shareholder vote. So far from denying it, Mr McGregor agrees.
I'm very sorry, Mr. Crow, to be so slow. You've taken us to McGregor at 7, page...
Page 108, I'm sorry.
Thank you so much, and I see it now.
Page 108, it's para 55 is the key passage.
I see it now.
That is the passage which the judge described as an ambiguous turn of phrase. In the context that we have just seen accumulating, it's not remotely ambiguous. It's answering a positive assertion, admittedly based on inference, but a positive assertion by Miss Berard that Mr Deripaska did control and cause. And the answer is, yes, he did.
Now, this affidavit is in support of the application to lift.
Yes.
We're sure, are we, that the affidavit of the 26th of June had been served by this time?
I
Perhaps
don't
just double check.
know
I'm sure you wouldn't be making a submission if it
should
hadn't.
be able to work that out.
Thank you. And where does the judge say this is an ambiguous phrase?
That is in paragraph 110 of his judgment.
Yes. So that there he's referring to McGregor 2
Yeah.
at 55. Because isn't there another one where another McGregor
Yep.
statement? Yeah.
There is indeed, and that is, yeah. So again, we need to take that one in context. So that's Berard 4, McGregor 2, and then we get Berard 8, which is tab 15. And if we look again at what she says in order to set up the sort of the dialogue, paragraph 67, page 207.
Yes.
Miss Berard quotes para 55 of McGregor 2. So she's saying that's the admission. McGregor's affidavit is made in response to that. So Berard 8 is November 2019. McGregor first affidavit is January 2020. He does not deny or retract para 55 of his second witness statement. What he does is, in our submission, properly understood, obliquely to confirm it. If we look at para 88, which is on page 250, bottom of page 250, para 88, for the avoidance of doubt, it is the vote on 20th December 2018 by B Finance as registered owner of the undertaking shares, and of which Mr Deripaska was the ultimate beneficial owner, controller, that the committal application complains of and contends amounted to a breach of the undertakings. So he is there admitting, in the face of his own previous statement about the shares having been voted, that Mr Deripaska is the owner and controller. If we look at his paragraph 194, which is on page 272.
Yes, that's the one I had in mind.
Yeah.
The wishes.
Yeah. He does say in the middle of that, it is not in dispute that B Finance voted in favour of the continuance in accordance with Mr Deripaska's wishes. He doesn't say, I was wrong to suggest that the vote was Mr Deripaska's vote.
That's the point that's but that's the point that's taken up in the judgment about wishes and not referring back to Mr Deripaska perhaps and agency, etc.
Yeah. Well, I'll deal very briefly with a legal submission about that. I just wanted to park the evidential position first. Finally, in this statement, this affidavit, paragraph 205. Fourthly, as set out, page 276, paragraph 205. Fourthly, he says, as set out in Mr Deripaska's fifth affidavit on these issues, when considering whether or not to support the continuance, he was focused on the commercial position of EN Plus and voting in a way most likely to be in its best interests. In doing so, he did not consider that it was not brought to his attention that B Finance voting in favour might be said to amount to a breach of the Deripaska undertaking. Now, in our submission, the only fair reading of that is that what Mr McGregor is saying is that Mr Deripaska was regarding the voting of B Finance's shares as his decision. He focused on the commercial position of EN Plus and voting in a way most likely to be in its best interests. So in our submission, it is perfectly clear that Mr McGregor was unable to say that Mr Deripaska did not procure the vote. He knew perfectly well what the issue was in the committal. And finally...
Does the judge refer to this evidence at all?
Well, he makes a very odd statement in paragraph 160, subparagraph 1 of the judgment. I think this is what he may be referring to, but I have to admit I don't actually know what he means. Because if we look at para 161, he's listing here various reasons why he says our evidence was tendentious, argumentative, irrelevant, and prejudicial. And at subparagraph 1, he says, it was said, this is him talking about our evidence, it was said to be now common ground that Mr Deripaska procured the passing of the shareholder resolution in December 2018 when it was not. That comment relied upon the ambiguous turn of phrase by Mr McGregor to which I have referred. Even if the claimants had in mind to argue that it was unambiguous, that paragraph was not in the evidence served in the committal proceedings. It had been extracted from Mr McGregor with no warning that what he said might be treated as an admission by his client on a quasi-criminal charge, i.e. without any heed to Mr Deripaska's rights as putative defendant in committal proceedings. I have to admit, with the greatest respect, I simply do not understand that. Nothing Mr McGregor said was extracted from him. He made McGregor too in support of his client's application to be released from the undertakings. There's no trickery involved. He then goes on to say, I do not suggest it is some deliberate tactic by the claimants to extract evidence unfairly and then use it against Mr Deripaska, but I do say it was unfair to try to use this evidence as support for a contempt charge. All the more so where the claimants knew from the evidence that was later served in the contempt application that Mr McGregor, had we got to him, would have explained what he had intended to convey by the earlier comment. Now, I think that is a reference to Mr McGregor's first affidavit, but I do not, in all conscience, understand what the judge means. Because Mr McGregor's affidavit does not explain what he meant.
Well, he doesn't say he needs to say any more.
No.
He doesn't say he would welcome the opportunity or down the line this will come.
No. And if the judge is speculating what Mr McGregor might have said in oral evidence, that, with the greatest respect, it would be entirely illegitimate. We are left with Mr McGregor's second witness statement saying what it says, and his first affidavit not retracting it. So,
but isn't the also? I'm sorry, you've made the point, but one knows how this litigation pans out. But Ms Berard, to put it neutrally, reinforces the point on the 14th of November, and that if it were not true, it would effectively have to be contradicted. I would expect it to be contradicted in terms.
Which is why, again,
the gauntlet's down.
Yeah, the use that is being made of it is perfectly openly deployed. The opportunity of answering is there, and the opportunity is not taken up with a denial. And with the greatest respect to the judge, his criticism of our presentation of evidence as being tendentious, argumentative, prejudicial is, with respect, just not fair. Last point, I think, on the evidence is Deripaska 5, which is going back to Supplemental Bundle 1, tab 17. And I think my Lady Justice Carr's already clearly got this in mind, because I think you referred to it, but at paragraph 8, one reads that carefully again, knowing what was being alleged, Mr Deripaska is plainly not denying that he procured the vote. Paragraph 8 says, with the benefit of hindsight, I now wish that the court had been notified in advance of the 20th of December shareholder vote on the proposal to redomicile. I now appreciate that I should have asked the court what the appropriate course of action to take regarding the vote was.
He says at para 37, I was aware the vote was to take place, I was not specifically consulted.
He does. Yes, sorry, you're absolutely right.
You
yes,
would say what he says. I'm sorry, Mr. Carr.
No.
But you would say that what he says at paragraph 8 should also be read in the context of what we've just looked at in relation to what Mr McGregor said.
Exactly so. And the last point, apropos para 37, is this, that what Mr Deripaska says there in para 37 is that he didn't give a specific instruction. And that is, as far as the evidence of Mr Valiev, I think his name is, goes. Mr Balliet says he wasn't specifically instructed.
And that's consistent with what Mr Deripaska says it. But he doesn't say he wasn't generally instructed.
No, exactly. And the answer to the question then is simply this. Is the judge right in saying that we had no evidence to support the alleged breach? I mean, it was pure speculation, his word, that Mr Deripaska procured the vote. Now, procuring doesn't necessarily need, in every instance, a direct and specific instruction. Our case, my ladies, my lord, is that Mr Deripaska plainly did procure be financed to vote as it did, because he made his wishes known, and he didn't retract that. For the purposes of the undertaking, that is procuring.
And you would say that that is in the first main paragraph at the beginning of 37 on page 297.
Exactly.
That it was the Barker plan was supported as a result of my general guidance.
Exactly. And it's a phrase he repeats in 37.2. While I was not consulted by Mr Balliet at the time before he provided confirmation, I do not dispute that it and B Finance's vote were in accordance with my general guidance. So if he's given an instruction, guidance, these are my shares, I want the redom to go ahead. The fact that we can't point to an email under which he specifically tells the de jure director of B Finance how to vote is neither here nor there. When the court is assessing whether or not there is evidence that Mr Deripaska procured, within the wording of Undertaking A, the vote in that way. There are a couple of additional grounds for upholding the judgment on which my learned friend wishes to rely. I just want to say a few things in anticipation so that he understands the case that we're putting, although I may need to say more in closing. So the grounds in his respondent's notice in relation to breach, they're in I don't know if you probably had seen them, it's tab 4 of the core bundle. And page 59. In relation to the...
I just reminded myself, and it's my fault, so Mr Pillows says he's going to assert that the shares as defined and the underlying assets continue to exist.
Yeah.
Yes.
So that's his first one. We don't understand, to be honest, why that's billed as an additional, because that, in our understanding, is what the judge was himself saying in paragraph 51. The next point, paragraph 6 of the response note, top of page 60, B Finance did not dispose of or deal with the shares when it voted in favour of the resolution that EN plus be redomiciled. And in consequence, the respondent did not commit a breach of the undertaking. That, I hope we've already addressed in our submission. It's not the fact of the vote, it's the consequence of the resolution that matters. Any actions, 7, any actions or omissions of the respondent were not the dominant or effective cause of the redomiciliation, and accordingly did not give rise to any breach of undertaking. In our submission, that is simply not a good point on the facts, because the redomiciliation required a special resolution of EN+. The Finance had 54% of the voting power. The voting of those shares in support as opposed to in opposition to the resolution was a necessary precondition to the redomiciliation. And the contempt by Mr Deripaska that we are alleging is not a contempt committed by him procuring redomiciliation. It is that he did not take all the necessary steps to ensure that the underlying assets remained available for direct enforcement. Because if he had taken the necessary step of instructing B Finance not to vote in favour, the resolution could not have been passed. So Millennium Friends attempts to rely on, he's giving you some case law, I think, on contractual causation. He's got Galoo and...
well, that's a professional liability case against accountants.
With the greatest respect, the question of, well, the issues that arise where a breach of contract has been committed and the court is looking at whether or not there is sufficient causation to give rise to a claim of damages. It's got nothing to do with interpreting these undertakings. So just to wrap up on breach, we submit that...
sorry, an unclear and ambiguous you've dealt with.
Oh, sorry. I'm so sorry.
No,
yes,
I'm just making sure.
Yes, no, you're quite right. I've skipped. Yes. Again, I don't think adds anything. Millennium Friend says that the judge was right to find ambiguity in paragraph 119 in our submission. That is just a false ambiguity. There is no ambiguity if one looks at these undertakings fairly with the intention of understanding them rather than the intention of trying to generate obscurity.
Oh, yes, yes.
Mm-hmm.
So I may not have covered everything that's in our written skeleton. I don't abandon anything that's there, but we do say, for the reasons given in writing and orally this morning, we do say that the undertakings were broken, and obviously a breach of only one would do. You may be with me on B but not A, or with me on A but not B, but we do submit that there was a breach of both or either.
But are you positively suggesting that this court should make absolute findings on breach?
Well, the outcome of what the court should do, I agree, is it could be open to some discussion, depending on exactly where you come down. I was going to suggest that it may be more economical for that debate to be had in light of the judgment, because the question whether or not the court should either remit the matter to be reconsidered on the basis of a correct understanding of the undertakings, and then with a view to be taken as to whether or not there would need to be cross-examination, is one way forward. If you feel satisfied on the material in front of you that you can reach your own conclusion that there has been a breach of one or other of the undertakings, then I'm certainly not going to dissuade you from adopting that approach. But as
the question of what may be relevant for the abuse argument may be a different one. But
yes, no, that's fair enough, and I think.
But for my part, certainly, Mr Crowe, anything that you want to say in relation to what we should do if we were to decide in a particular way, I would be grateful if it were said here and now, not exactly here and now, but during this hearing,
of course,
rather than at a later stage. I think that's just much better all round.
Okay, well, I'm grateful for that indication, and we will do exactly that. Could I spend the last sort of 10 minutes before the break opening up on abuse? So we, as you may have seen from our notice of appeal, we've got 5 grounds of challenge to what the judge decided. And just to sort of remind you, first of all, we take issue with his decision that an applicant in an abuse case such as this has to assume the role of a dispassionate public prosecutor. So that's the first question. Second point, the judge took into account significantly the personal animosity that he said that my client bore towards Mr Deripaska. So the question of personal motive is the second legal issue. Third question that we are going to deal with is the relevance of Mr Chernukhin's knowledge of the proposed redomiciliation. You, my ladies and my lord, will recall that there's quite a lot in the judgment about what Mr Chernukhin knew and when about the redom and what relevance that has to the question of whether or not the committal application was an abuse. Fourth point, we will deal with some of the judge's unkind findings in relation to whether our evidence was misleading or not. The fifth point, I don't need to add anything to, but the fifth point in our grounds of appeal is that the judge was wrong ultimately to find that there had been no breach. Before dealing with those, can I just top line a couple of introductory points, which I hope will then set our submissions clearly in context. First of all, just in terms of the test on an appeal in relation to a finding or a rejection of a finding of abuse, I think the legal framework is not in dispute between the parties, as far as one can tell from the skeletons. I think there are three propositions of law. The first is that there is only one right answer to the question whether or not a particular step in litigation is an abuse of process. It's not a matter of discretion. It is a right or wrong answer. Second proposition, having said that, in reaching an answer on that, and a first instance judge has to assess a number of factors and reach a judgment by balancing those different elements. So an appellate court will be, it is said, reluctant to interfere in the generality of cases. But the third proposition of law is that an appellate court will interfere if the first instance judge has taken into account immaterial factors, or omitted to take into account material factors, or erred in principle, or has come to a conclusion which wasn't open to it. And so, as I say, I think that framework for submissions is not in dispute. We do say that the consequence is going to be that if we are right on any one of our grounds of appeal, that is enough to subvert the integrity of the judgment, because the judge will have put into the balance something he should not have done. So this is not one of those situations where I've got to win on all 5 of my grounds. I can win on any one of them, and that will be sufficient. Second thing I just want to do briefly is this, is to look, and I foreshadowed this to some extent in answering one of my lady's questions. I just want to look very briefly at the legitimate purposes for which a committal application can be brought. And in our submission, there are, slightly depends how you describe them, probably 3 legitimate purposes. One is encouraging or coercing compliance with a court order or undertaking. The second is punishing a past breach. And the third is deterrence, deterring either that particular contemner or just sending a signal to persons generally that disobedience of court orders is not tolerated. So, coercion, punishment, deterrence. So far as the second is concerned, punishment. Punishing past breaches is entirely a legitimate purpose, irrespective of whether the breach has been remedied or is incapable of remedy. We'll see there's some case law making perfectly clear that even though a breach may have been remedied, that does not mean that the contemner can skip free. Now, I think it's helpful also, because the other thing I will get onto after the short adjournment is the difference between civil and criminal contempt. So I won't get onto that now, but I do just in the last few minutes want to leave with you the decision in Sectorguard, which, as I suggested earlier, it provides perhaps the most helpful roadmap for dealing with this area. And it's in the first volume of the authorities at tab 11. The context in which the decision was taken was an action which had been brought by a company against former employees and their new company for alleged misuse of customer lists and so on. And an order was made that the new company and its directors should make an affidavit setting out a list of which customers of the claimant had been contacted. And it turned out that it was literally impossible to comply with that. Sorry, it's an undertaking. If I said order, I was wrong. And that undertaking was given. It turned out it was literally impossible to comply with that undertaking because although it appeared that a list of customers had been taken, it had then been destroyed. And the new company had not kept a track record of who on the list it had contacted. So that was an illustration of literal impossibility. They just didn't know. That does help one in dealing with the question of impossibility we were looking at earlier as well. So if we just very quickly run through a couple of paragraphs. Page 129, paragraph 7. If the court will just kindly read that to yourselves.
Yes.
And then if we go on to over the page, paragraph 15, where the judge says that his reasons for permitting the adjournment of the permission application, notwithstanding Diane and Mr Hare's opposition, are less straightforward. It is well settled that proceedings for contempt of court for which permission has to be obtained are public law proceedings, so that when considering whether to give permission for contempt proceedings to be taken in any particular case, the court must have regard to the public interest alone. And he cites KHAM Superbikes. And then at the last two lines it says, there is an obvious need to guard carefully against the risk of allowing vindictive litigants to use such proceedings. That is, proceedings for which permission has to be obtained, to harass persons against whom they have a grievance, whether justified or not. In that context, the court must bear in mind, in the case of a serious alleged contempt by the making of false statement, that there is an alternative wholly independent applicant, namely Her Majesty's Attorney General. And then over at page 133, you see paragraph 25 explaining the literal impossibility of complying with the undertaking as a result of the destruction. And then if we go over to page 137, we pick up, and it's the whole of paragraphs 44 to 58 are sidelined. I'm not going to read those in court, but could I just particularly urge on you paras 46 and 7 now? And just indulge me a few minutes. 46. It has long been recognised that the pursuit of committal proceedings which leads merely to the establishment of a purely technical contempt, rather than something of sufficient gravity to justify the imposition of a serious penalty, may lead the applicant having to pay the respondent's costs, and some authorities cited for that. 47. Committal proceedings are an appropriate way, albeit as a last resort, of seeking to obtain compliance by a party with the court's order, including undertakings contained in orders, and they are also an appropriate means of bringing to the court's attention serious, rather than technical, still less involuntary, breaches of them. In my judgment, the court should, in the exercise of its case management powers, be astute to detect cases in which contempt proceedings are not being pursued for those legitimate ends. Indications that contempt proceedings are not being pursued include applications relating to purely technical contempt, applications not directed at the obtaining of compliance with the order in question, and applications which, on the face of the documentary evidence, have no real prospect of success. Committal applications of that type are properly to be regarded as an abuse of process. All of that is being said by reference to what the function of the application are, not what the motives of the applicant are. And finally, just over the page at 53, my conclusion that the application has no real prospect of success is of itself sufficient to render its further prosecution and abuse. Nonetheless, there is a second reason pointing in the same direction. It is that on the evidence as a whole, I consider it more likely than not that the application has been prosecuted otherwise than for the legitimate motive of seeking enforcement of Undertaking 5 or bringing to the court's attention a serious rather than a purely technical contempt.
So that is looking at motive. And
No, no, with respect, it's not. What it's saying is that because the undertaking was broken, because the new company did not provide an affidavit listing the customers, it was a technical breach, not a serious one. It's not a question of motive. It's a question of what is the object that is being brought before the court. And that, in our submission, is an objective question. Nothing is said about motive. It is purely a distinction between a serious and a purely technical contempt.
But the first part is obviously legitimate motive, and that takes you back to the legitimate motives that have already been considered.
Exactly so. I'm sorry, I've overrun slightly, but would that be a convenient moment?
Thank you very much. Yes, it would. 2 o'clock. Thank you.